Good afternoon, sir. What's your name, please?
Brandon Jones.
Thank you. This is case 24-055-104, State of Michigan versus Brandon Jones. Counsel.
Good morning, Lisa Coyle, appearing on behalf of the people.
Good afternoon, Your Honor. Kashava Kirkland on behalf of Mr. Jones, who has been advised of his rights, wishes to skim mute, waive the formal reading.
Court will enter not guilty plea on your client's behalf. As to bond, please.
Your Honor, the people in this matter requesting $200,000 cash surety and a tether. The allegations are in this matter is that he lived with the complainant's mother for over a year. The complainant is an 8-year-old girl. And the allegations are as follows: that the defendant, while in bed, touched her vagina with his hand. She pushed him away, and then he inserted his penis into her anus. The mother was at work when the assault occurred. The only thing I see on his record is a 2015 domestic violence that was deferred under 769.4A. Something I saw also was that he was found hiding in a closet under some clothes and bags when he was arrested for this CSC 1, that he was violating a no contact order. Based on the allegations regarding the 8-year-old, is extremely troubling. The allegations are sometime from the timeline of June 1st through July 4th when this occurred. That's what the 8-year-old reported. For that matter, of course, I'm asking also no contact with the complainant in this matter or any minors until this matter proceeds through court.
Thank you.
Your Honor, I want to make sure I do my due diligence. Attorney Coyle, did you say when he was arrested on this, he was found hiding at the complainant's home, violating a no contact order?
Yes.
May I have that document, please? Because I don't have that.
Okay, I don't. I'd have to pull it up and redact it. And it was done. I saw some sort of police report upon his arrest. So I don't know if that, I'm not attributing that no contact. I'm not sure if that no contact order is for this case, but he was arrested hiding. It's something I assume you can confirm with your client as well.
Your Honor, I would need that document. If the court is going to consider that, ask for that document. Mr. Jones is entitled, if the court is going to consider that, to his counsel to have access to that document, because I don't have anything in front of me that says that.
Okay, I can.
Counsel, both of you. Court's not going to consider that at this point. Court's considering that a complaining witness is 8 years old. So what do you have to say for that, Ms. Kirkland?
Thank you, Your Honor. Mr. Jones, so in this case, we're asking for a 10% bond if this court would not consider a high personal bond. He is a lifelong resident of the Detroit area. He has 6 children. Now, he understands the seriousness of these charges. My understanding is he has nothing on his record that aside from that deferred DV that was dismissed. There's nothing that he's ever been arrested or convicted of. That he has no pending cases, not currently on probation or parole. I wouldn't even object to a tether or house arrest. I just ask that he be allowed to go to work. He does work at Ford Staffing through a temp service. At this point, there's no amount of bond that he can afford to pay. He does fall within the guidelines. And just, we understand the seriousness of the charges, and Mr. Jones understands the seriousness of the charges. And once he received, the police actually made contact with his brother first. And once his brother let him know that the police were looking for him, he immediately made contact with the law enforcement. Initially agreed to come down and spoke to speak with law enforcement, but after speaking with his attorney, was told that he probably should not go down and make a statement. That's what I have regarding his participation in this, is that he has been compliant and that he was going to make a statement but chose not to after consulting with an attorney. And just to do my due diligence, the report does say that, a medical exam was, conducted and that there were no signs of trauma or injury. I understand that this is an 8-year-old and Mr. Jones looks forward to his day in court. He's not a flight risk, and I believe that any danger he may be to the complainants or the community can be combated with a house arrest with the provision that he only be allowed to leave for work.
Thank you. Allegations here are extremely troubling. Really? Anal sex with an 8-year-old girl. So here's the bond. GPS tether, house arrest, no contact with a complaining witness, no contact with a Chatsworth Street address, no contact with any minor children. Bond is $500,000. Cash for surety. Bond redetermination date is Tuesday, January 9th, in front of Judge McConico. Probable cause, January 17. Preliminary exam, January 24, both in front of Judge King. All of that in 36th District Court. Thank you, sir. You can step aside.
Thank you.
Case number 240-551-0401. People of the state of Michigan versus Brandon Jones. Defendant is being charged with count 1, criminal sexual conduct, first degree, person under 13, defendant 17 years of age or older, SORA notice. Count 2, criminal sexual conduct, second degree, person under 13, defendant 17 years of age or older, SORA notice. Today is the date and time for bond hearing. Appearances, please.
Judge, good morning. Always a privilege. Steve Vincent for the people, P71917.
Judge, and good morning. May it please this honorable court, we're breaking 57156 on behalf of Mr. Brandon Jones, Your Honor.
State your name for the record.
Brandon Jones.
Argument.
Judge, Judge, I went over this, Judge, and I kind of found this particular case a little confusing. There were allegations, Your Honor, that came in, I guess, on the 31st of July that alleged that Mr. Jones participated in this activity between June 1st and the 4th of July. Now, what I looked at, Judge, he has no prior criminal history. We did discuss this case. There were reports done, Judge, sometime in it looks like October. They started investigating this in October. But what really kind of disturbed me was that there was a CPS report that was put in by a teacher, and that wasn't put in until August 28th. And it wasn't until August 28th that there was some type of exam done on the complaining witness. And when the exam was done on August the 28th, there was no signs of any trauma, no signs of anything wrong. Now, we're talking about a person that's young in age. Not sure, and I don't understand why there wasn't an exam done earlier, why there wasn't any type of activity or reports done earlier. But why did we wait until this teacher put a CPS report in about this in August? It just doesn't make sense. A lot of this didn't make sense, Judge, when I read it. I don't know if it's the way it's investigated. There are a lot of witnesses that really don't say anything. They just say witness statements. It's just very confusing, Judge. You think that if there was some type of trauma of that nature, when I read the report, I was very disturbed at the allegations. If there was some type of trauma to that nature, that you would do something immediately. There would be some type of injury, hurt, complaining. Somebody would say, hey, this, it's not right. And this would be taken care of long before August the 28th, from July the 4th, between June and July. So that, I found that very, very interesting, Judge. I'm not really sure. Obviously, Mr. Jones is going to have to go through this process. Again, he has no priors. He works every day, has 6 children. But I think that there's a lot more to this, Judge, that's not being said because it just doesn't make sense when I read it. I'm asking the court, Judge, the bond is $500,000 cash as surety with GPS tether. He has no priors. He will not have any contact with any minor child, Judge, based just on the nature of the allegation. I'm asking the court to reduce the bond to a personal with the GPS tether house arrest. And that would be my request, just based on the fact, Judge, when I read this was not a normal situation in terms of how this whole thing is played out through the investigator's report.
Okay, quick question. Is the bond a $500,000 or $5 million?
I have 500,000 cash as surety. GPS.
Our ROA reflects 5 million.
That's what I thought.
Okay. And I could be wrong, Judge. That's what I had. But I'm asking for a reduction, Judge. And again, it just doesn't make sense based on what I read.
You're asking for a reduction from 5 million
to 5 million personal with the GPS tether, house arrest, and that, no contact with any minor children, obviously, because it's just the nature of the charges. But I'm disturbed by the whole thing, the allegations, plus the investigation, plus what I'm reading about, the timing of this and how, this seems like it should be an urgent situation, and just didn't seem urgent. I don't know, Judge. It just doesn't seem right. I'm having a lot of doubts about this.
Prosecutor.
Judge, I'm going to start by saying I don't think there's any protocol.
Okay, I'm sorry, Mr. Prosecutor, to cut you off. There must be a technical error. I guess Magistrate Boyer is watching the bond redetermination hearings. Madam Clerk, make a change in the ROA. It should be 500,000 and not 5 million.
Okay, I'll change that right now.
Yeah.
Okay, Mr. Prosecutor, so it is 500,000, not 5 million.
Thank you, Judge. And whether or not it's 500,000, 5 million, 50 million, I think the way that I'm just going to begin this, and I'm going to be brief, there isn't a protocol for an 8-year-old to report a rape by a 32-year-old where allegedly a 32-year-old puts his penis in her anus. There is a protocol. So if this 8-year-old ended up telling her school teacher a month later, if she ended up telling her aunt 2 months later, whatever it was, she ended up telling somebody. She actually ended up telling multiple people. And then she went into a kids talk interview and she drew pictures. And those talks that she had in the kids interview with the individuals that she told this incident to, they were consistent through and through. Those didn't change. So when she told her teacher, and then she told her auntie, and then she told another auntie about this, everybody heard the same thing from this little girl. And it was reported that she had pain. Did she know what to do? No. Apparently she didn't know what to do. I mean, in all due respect to Mr. Reagan, in the perfect world, something like this happens, and then I guess this 8-year-old goes straight to the police. I guess she just takes her bike or whatever and tells them what happens. That in the real world, what happens is, and something like this happens to an 8-year-old, and then the world gets turned upside down. And you talk about trauma. It's not just the physical trauma that we're talking about here. It's the mental trauma. We have an individual who, I mean, for all intent and purposes, he's in a position of authority. He's a predator. He took advantage of the situation. And now we have an 8-year-old who ended up sustaining this incident, this injury as a direct result. So quite honestly, Judge, I look at this as a disturbing incident for the complete opposite way that defense counsel is looking at it. And for that, Judge, I'm going to be asking you to continue this at the very least. Now that I know it's 500,000, he's being charged with the first and second degree criminal sexual conduct. That first, as you know, is a life offense. and just the age of the individual involved and what she ended up telling people, corroborating everything. We do feel as though he's a danger, and respectfully, we're going to ask you for that $500,000 to continue.
Well, Judge, I need to make a record real quick because let's get into this since Mr. Vincent wants to get into it. So it's very disturbing. The allegations are disturbing, but it wasn't 2 months. The report was made July 31st, but there wasn't an exam done until almost a month later. So let's not say that she waited 2 months or it's not a time. The timeline isn't important. I think it's very important. And I think that and she is 8 years old, so she does have guardians. She has parents. So when you talk about making a report of something that happened on July 4th or going in and the police start investigating July 31st, but then the teacher doesn't make a report for CPS until the end of August, almost a month later, there's some problems with the timeline. And when you get an examination almost a month later, when you make the report on the 31st, you take the child in on the 31st and you get an examination in. You don't wait a month to try to get an examination on allegations like this. That doesn't make any sense. And it doesn't make any sense that when you go in a month later, they says there's no damage, there's nothing wrong. It's nothing, you know what I'm saying? There's no anything. And, and obviously, I think the allegations are disturbing, but I think everything around the timelines and what happened, and I don't have maybe everything that you have, because all I have is that it happened on the 28th with this exam. They found nothing, but yet it was reported on the 31st, and it wasn't until the teacher went to CPS. The teacher made a CPS report against somebody, and that's when they went to have an exam. Not before that. That's a problem to me. That's a major problem, And I'm not saying one way or the other. I think the allegations are horrendous, But obviously, there's going to be a case, a trial. It's going to go forward, and obviously, there's a lot of folks traumatized here. I feel I'm not trying to promote this, but this is not a situation where we're trying the case today. This is a bond here. It's not a trial, just a bond here. Whether or not, there should be a bond reduction or not. Now, my thing is Mr. Jones has no prior record. He's presumed innocent until proven guilty at trial. We're not talking about, saying not guilty today or guilty today. We're saying that is he a threat to the community? And I'm saying based on the lack of prior history, if you put a tether on him, if you put him on house arrest, do not let him out the house. Do not let him near any children. I think based on that, and based on what I read and some of the doubts that may be here, that may be sufficient. That may be sufficient in terms of bond. That's it. Not whether there's guilt or innocence or anything like that, but in terms of bond.
Court haven't heard the arguments of counsel. This is a case. I mean, this is a situation where both I can agree with both the defense and the prosecutor. On the defense side, there seems to be it is a little. I mean, the timeline, there should have been some urgency, not on behalf of the victim, but on behalf of the system, that things got in motion, it seems like, after the CPS report was made. Why things weren't going faster before then? I don't have an answer to that. But that has no impact on whether this happened or not. And there is nothing, there is no right or wrong way, as the prosecutor stated, for an 8-year-old to proceed after being sodomized allegedly. I mean, there's really nothing. There's no playbook for an 8-year-old to go through after something like that allegedly happened. So with that being said, and now having corrected information, that the bond is not $5 million. If the bond was $5 million, the court was going to hold that was excessive. But the court, bond being $500,000, the court finds that is an unaffordable bond. But with these allegations, the court finds that the defendant is a threat to the community, the complaining witness, and the $500,000 bond is appropriate. Along with the $500,000 bond will be a house arrest. no contact with anyone under the age of 18, and no contact with the complaining witness or the complaining witness's brother or complaining witness's mother or the complaining witness's aunt that this recorded call.
Thank you, Judge.
Thank you, Your Honor.